Okay. All right, welcome back. Class number 8. We are basically a third of the way through the semester. It's insane how fast this semester flies this summer. Please check in for the attendance. So you asked me about Justice Brennan. Why?
I don't know, because I feel like reading other cases from like Civil Pro and stuff, I feel like more than Justice Stevens being the polar opposite of Justice Scalia, I feel like Justice Brennan seems like more like the opposite in his opinions.
Okay. Justice Brennan was appointed by Eisenhower in what, 53 or 54? Check me on the year. And then he died in, I guess he died around 90, or he retired in 91 or so, or 90 or 91. So Brennan only overlapped with Scalia for about 4 or 5 years. So they didn't have much of an overlap. And on the time when Brennan overlapped with Scalia, the conservatives had a minority on the court. After the appointment of Justice Thomas, the conservative majority somewhat cemented, although not strongly. So Justice Stevens had a much longer running dispute with Justice Scalia than Brennan did by virtue of the fact they were on the court for very long. And the years that Brennan and Scalia were on the court together, they didn't have nearly as many conflicts. Which is not to say that they didn't disagree on stuff. I'm sure Brennan and Scalia sparred quite a bit, but just they didn't have as much tenure in the court together. This semester, Brennan opinions in ConLaw. Which ones? I think you might have in this syllabus, maybe 1 or 2, not many. Justice Brennan was influential not because of his reasoning, but because of his ability to cobble together a majority opinion. There's an old anecdote, which might not be true. People dispute it, but there's an anecdote at least, where Brennan would tell his law clerks, what's the most important number around here? And he would go 5, because with 5 votes you can do anything. And Brennan was uniquely skilled at holding together majority opinion, even if it didn't really say that much. It didn't really matter. The result reached was important enough to get 5 votes, and then maybe they could fix it up later. And he was very good at that. And you'll see this in the context of the gender discrimination cases. But there are not many Brennan opinions today that, at least in ConLaw, that really goes like, oh, wow, that's a great opinion, right? So, oh, wow, you talk about Justice Holmes or Brandeis or Jackson or Cardozo. Brennan doesn't really have any of those. His skill was making 5 votes work, and beyond that, didn't really matter.
Yeah, the reason I asked was because the case that I'm thinking back to is the Brennan divorce case.
Which one?
I believe it's called the Brennan divorce case, where it was by yes, that one. Where
he moved to Texas and ran for Congress in Dallas years later. That was kind of weird. Like nobody voted for him, but anyway, he's a Texan now.
Oh, good.
So because in there it was all 9 Supreme Court justices were in agreement that the husband the state of California had jurisdiction over him, but Justice Brennan and Justice Scalia had concurring opinions on why that was. It was just really funny, like when I was reading that, it basically looked like they were just going, no, my opinion is right, not yours.
Yeah. I mean, Justice Stevens, I think I talked about him enough last class, but he was very, very vocal when he thought other people were wrong. He's still vocal now. He's off the court a decade. He's been off the court, oh my God. He stepped down in 2009. It's been 10 years since he left the bench. Oh, wow. Flies. It really flies. I remember my 3L summer, when I should have been studying for the bar, I watched the Sotomayor hearings, gavel to gavel, the entire thing from start to finish. That was in 2009, so I guess Stevens would have been 2010 the next year. So 9 years he's been gone from the bench.
So almost a decade.
Almost 10 years. Goes fast. You won't even believe it. I finished law school 10 years ago. It doesn't even feel like it. It will fly by so quickly. You won't even know it. You won't even remember it. All right, let's do some law. All right, let's start a poll. Okay. So let's start with this question, right, to get us thinking. Article 3 of the Constitution allowed a citizen to sue another state in federal court. True or false? We're all here. Not all prepared, but we're all here. Okay. One of these days we'll all be here and have all read. It'll happen eventually. Tomorrow, I think. Okay, very good. Let's see what we got. All right. Good, I like that breakdown actually. So let's start with a basic question before we get to the results. Lindsay, I'll start this row. Generally, when someone has a grievance with the government, right, how are those grievances resolved? All right, your local Trinity County City Council, whatever the local government is there, right? The government does something wrong. Generally, what are you going to do?
Go to your representative.
And what are you going to say?
That you're not happy with what's happening.
Uh-huh. And what they say, too bad.
You could file suit.
Don't say courts. No, I'm not
Okay.
there. Don't say courts. We'll get there eventually. But short of going to court, what can be done in the event of a dispute between you and your local government?
Other than representatives, maybe petitions or local movements.
What happens if politicians do stuff you don't like?
You can vote them out.
Vote the bums out of office, right? Vote them out of office, right? As a general matter, when a local government does something not to your liking, the remedy is political. You can maybe tell them you don't like it. You can say you're not happy with the ruling. You can say, I'm going to challenge you in the next election, right? You can run a candidate. You can run yourself. You can hand out pamphlets and flyers, and you can tweet about them, do all these other things to try to put pressure, right? Now, Chelsea, what happens if, let's say you live in Texas, right? And then the state of Oklahoma does something you don't like. And the Oklahoma government screws you over and leaves something that you're really not happy with. What's your remedy there?
You can't sue them.
Well, no, forget the courts for a minute. Just lawsuits love courts. That's all they know. No, I'm talking just as a general matter, right? The government in Oklahoma does something that you don't like. Well, what's your remedy? You're a Texas citizen. Can you vote them out of office?
No.
Can you complain to them? Will they even answer your phone calls?
Um,
No. If anyone ever tried actually calling members of Congress, the first question they ask you is, where do you live? Right? Right? Yeah. What district do you live in? Right? Which, are you my constituent? If not, have a nice day. Right? Because if you're not their constituent, they have no obligation to even care what you think. I mean, maybe they will if they're a nice person. They'll talk to anyone who comes in their door, but they're busy people, right? They're elected officials. Okay, so this is a basic gist, right? If your own government does something you don't like, you can use the political process, you can vote, you can campaign to try and get them to change their mind. If a government of another state does something you don't like, well, your options are less. Okay, so now let's take a step back and think of courts, which is what you all want to say, right? So Audrey, all right, let's say that you live in Houston. Okay, so let's just say Houston raises your property taxes and you don't like how much your taxes are. Can you go to court and sue them?
Are we talking about under Article 3?
Forget the Constitution for a minute, right? If your government does something you don't like, can you sue them?
No,
Why not?
because the citizen can't sue them.
Forget the 11th Amendment for a second, right? As a general matter, if your government does something you don't like, can you take them to court to sue them?
Sure.
And what's your argument going to be? I don't like this policy, it's a bad idea.
I would say bring it under federal question.
You guys are thinking way too big, right?
Right.
Your local city council enacts a law you don't like. You think that's a bad law. Can you sue them so just say, I don't like this law, it's a bad law? No. Right? What's a remedy generally if the government passes a law you don't like? Yeah. Try to get the government to repeal it. Right? I'm trying to get you to think of what generally government works, right? Most grievances with the government are resolved through the political process. All right? Tyler, right? Tyler, Now let me ask you a different question, right? Let's say that you own a business, and you contract with the government, and you say, I'll provide you certain goods for a certain price, and the government just says, no, we're not going to pay you. We'll take your goods, we're not going to pay you for it. What would you, as a business owner, what would you usually do in that situation? You contract to sell some goods, and they take the goods and never pay up.
Government breaches a contract?
Yeah, government breaches a contract. What in a normal case, what would you do if there's a breach of a contract?
First, seek civil remedy.
Okay. And how do you seek a civil remedy? What do you usually do?
Remediation, arbitration, file suit.
Okay, lawsuit, that's what I'm talking about, right? So generally, right, if you have some sort of dispute with the government, that's not over a policy. It's not like, I don't like that law. If there's an actual business dispute where, say, they breach a contract or they commit a tort or things like this, you take them to court. You might seek damages. You might seek what's called specific performance, or what we might call injunctive relief, right? If you enforce the damn contract, we promised, you made a deal, right? So, I'll just skip you, Fabian. So, Sarosh, let me ask you this question. Should the government be treated differently for purposes of a lawsuit? Right? If you and I have a contract and you breach, I can take you to court just fine. But government breaches plays out a little bit differently, doesn't it?
It does.
Why should the government be treated differently for purposes of breaching a contract? Simple thing. Forgetting the 11th Amendment, right? Just put that aside for a minute. But as a general matter, should the government be treated differently for purposes of these sorts of lawsuits?
In my opinion, no.
Okay. And for you to be right, what would that mean? What would the consequence be if you're right? That the government should be treated no different than a private litigant?
The argument for that, or you're asking the argument, right? Or the result?
Yes. What would happen if you were right, if the government was treated no differently than random people?
Then the government would not be above the law.
Okay. And then what would happen then if a court awards damages?
The government would have to pay up.
Okay. And where's that money come from?
The taxpayer.
And how does a court order the legislature to withdraw money from
Taxes.
the Treasury? Taxes, right? There's that. Well, let's ask a different way, right? In order for you to go to a court to sue, what does a court have to have in order for that lawsuit to begin? Jurisdiction. So why couldn't Texas just tell their state courts, hey courts, guess what? We are not giving you jurisdiction over any lawsuit against the state. Could a state do that?
They could, because technically speaking, in the Oklahoma case, if Ality is trying to sue Oklahoma, they have the state of Texas does not have jurisdiction.
Is Oklahoma obligated to give a forum for citizen suits?
No.
No, they're not. So you can't sue in state court. So what might you try to do?
Take it in federal courts.
Okay, so here we go. This is what I'm sort of leading up to this question, right? I think everyone would agree at the time of Chisholm, right, when Chisholm was decided, that Georgia, the state, could control the subject matter jurisdiction of its own courts. That the state of Georgia could say, we are not allowing citizen suits against the state for sovereign immunity, whatever. We'll get to sovereign immunity in a few minutes, right? But we all agree that at the time Chisholm was decided, the state could exclude from its own courts subject matter jurisdiction for citizen suits. Okay? But what about federal suits? All right, this is not a question then of whether a state's own courts could hear the case, but whether the federal courts could hear the case. So I asked the question here, Article 3 of the Constitution allowed a citizen to sue another state in federal court. So let's start and walk through Article 3, Section 2. Right, let's just walk through it. So we did this provision, I think, in the second class. We did Marbury. It says, in all cases affecting ambassadors, other public ministers, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. Okay? Now, it says cases in which a state shall be a party. Lindsay, does that indicate what role the state has, whether the state is a plaintiff or the defendant?
No.
So in theory, the state could be a plaintiff and sue in the Supreme Court's original jurisdiction, or the state could be the defendant and be sued by a citizen. Okay? We go down to the next paragraph. And it says, the judicial power shall extend to controversies between a state and citizens of another state. And Lindsay, one more time. Does that paragraph have any clarity about whether the plaintiff is the state or the defendant is the state?
No. Well, there's one argument for the order in which you read the parties.
So it says state first, citizen second, which suggests maybe that the first one is the plaintiff, that is the state, and the second one is the defendant, that is the citizen of another state. All right, and this is actually the controversy we'll see in Chisholm and Hans. But I want to focus on the text for just one more minute, please. Right? You learned in Civ Pro, right? Why do we have diversity jurisdiction? The idea is because the local court will not be fair, right, to the out-of-state litigants, right? That if Chelsea wants to sue a citizen of Oklahoma, then Oklahoma courts will not be fair to Chelsea, right? We all learned this in Civ Pro first year of law school. But I don't think you talked about this one in Civ Pro, did you? So Chelsea, just let's make clear. Why would a citizen of Texas want to sue Oklahoma? We sort of already said it a minute ago, but let's just say it one more time more clearly. Why would a citizen of Texas want to sue the state of Oklahoma? Very good. Yeah, it's not just Oklahoma enacts a law they don't like. It could be a breach of contract, for example, or maybe you were traveling and an Oklahoma official engaged in a tort. You know, you could make up 100 different, examples of what happens. Right? So you can understand why, as a theoretical matter, a citizen of Texas would want to sue Oklahoma. Right? We can understand why that is. The question is, can they? Right? In other words, by giving the courts subject matter jurisdiction over these diversity suits, where a citizen of one state sues another state, does that then force the state to be amenable, use a different word, available to be sued in federal court? So now we go back to this poll. I mean, we have 5 people or 6 people. I think the better answer is it's true. I don't think that the first versus the second, the plaintiff defendant. I mean, it's a good argument for sure, but the language here is pretty broad. And I think so long as the state's a party, as an original matter, the courts have jurisdiction.
Well, I guess it means a lot of different things to a lot of different
It does, and I'm so glad you said that.
Yes.
Students don't even know what that word means because it's a word that's used a lot, but it's never actually defined.
Do you want me to go along with our first case?
Well, forget this context. As a general matter, what does sovereignty mean?
Power.
Power.
That's what.
Yeah, power. Power. What other words come to mind?
Of power, but the argument is who has the sovereignty? It's the people or the state.
Okay, no, you're good. You're good. Okay. Okay. So you say sovereignty is power. Tyler, let me ask you, how would you define sovereign? Not sovereignty, but sovereign. What's sovereign? No. I get immunity's my next question. They throw sure on deck with immunity, but just stick with sovereign, not sovereignty. She gave me sovereignty. She said power. Sovereign. What does sovereign mean?
Controlling, yeah, like severable and controlling.
Severable. What do you mean severable?
As in not reliant on any other concurrent or proceeding.
Like maybe supreme?
control. Correct.
Like at the top of the pyramid, right? No one's below him. Okay. So sovereignty is power. Sovereign is no one else controls him, supreme. And then Sarosh, I see you have a dictionary. Dictionaries are very helpful. I'm glad.
I mean, I'm going with Mr. Garner's.
Mr. Garner's a very good person to go with.
sections of
He's
bylaw.
a very good person to go with. I had that same dictionary as the one of the little black one. The little black's the handheld one. All right, Sarosh, give me, what does immunity mean?
Immunity.
You have to look it up. Just tell me in your own words.
Well, immunity basically means that you are not subject to the jurisdiction. I don't know what it is. You're not subject to the laws, or basically, if from the case in Chisholm v. Georgia, what I understood was it basically means you can't be held liable under.
Very good. Very good. Okay. Immunity suggests that you cannot be held liable. I like that word. In the courts of law. Right? You cannot be held liable in the courts of
I
law.
have a question.
Please.
on that.
Please.
Is that from the development of that in the 11th Amendment? Is that where we get the concept of diplomatic immunity?
Diplomatic immunity comes long before the 11th Amendment. This is a concept that existed for millennia, right? You'll take classes in international law and other related disciplines, but it's a very old concept that diplomats are not subject to the courts of whatever jurisdiction they're in. I mean, exactly right. And Sarosh, I think you raise a fair point, right? Why are diplomats immune? Right? Can you imagine the dangers you'd be of being an ambassador from a country if you could be thrown into court on trumped-up charges and be held in jail on bogus charges? Right? No one would volunteer to become an ambassador or a diplomat if they knew that they can be locked up. And in truth, to make this point more bluntly, when you are the ambassador or the diplomat of a king, for example, you actually are the embodiment of the king's presence, right? The same reason why the United States could not jail the King of England, or the Queen as it were now, is the reason why you can't jail their messenger, their ambassador. They are basically a manifestation of the state's authority, which is in large part why there was such a debate in Chisholm, right? We all agree in England before the Revolution, the king could not be sued in the courts, right? There was no jurisdiction to even sue the king, right? You couldn't do it. And it was based on a concept known as sovereign immunity, right? The king was known as a sovereign, or the queen as it were, whichever in the time period there was, that the queen had this power and there was no one above him or her. And because the king could do no wrong, the king could not be sued in court. Right? We all agree that that's true. That's how England worked. But the question becomes, what happened after the American Revolution in 1776? I've told you before that after the Declaration of Independence, whatever powers that the king had went to the states, right? The powers to conduct commerce, the powers to tax, the power to the police power in general, right? Whatever police power the king had fell onto the states. And then we said when the Articles of Confederation were approved, the states relinquished some of their power, which they gave to the central government. And when the U.S. Constitution was ratified in 1789, the states relinquished other powers, which were given to the central government. The question in Chisholm boils down to this. Did the states relinquish the sovereign immunity that the King of England had? Did the Constitution give up that power to be immune from suit in the courts of the United States? Right? That is the question presented in Chisholm. And the argument that they gave up this immunity is Article 3, Section 2. Right? Article 3, Section 2, which says, again, the judicial power shall extend to controversies between a state and citizens of another state. And the argument advanced by Chisholm is that this one sentence, which all the states ratified, that this one clause surrendered their own sovereign immunity. That one clause gave up their freedom from lawsuits, the freedom that the King of England had enjoyed before. Right? In other words, the sovereignty after independence rested with the states. And the states then gave that up. Or did it? The Chisholm court split on this question. It was a 4-1 vote. We'll go through the judges in a minute. Right? But it was a 4-1 vote. One justice thought that the states retained this sovereignty and this one sentence doesn't give up the jig. 4 other justices disagreed. They thought that the sovereign in this new republic was not the states, but it was we, the people. And that the sovereignty rested not within the states, but within the individuals.
Wait.
Yeah, go ahead.
Last we discussed, didn't the Supreme Court eventually end up saying that we, the people, are not the sovereign, but the states?
Oh, they said that. But what was correct as an original matter?
We, the people.
Well, that's a question in Chisholm, right? Chisholm was what, 1793? Oh, I'm sorry, 98. I'm sorry, I was off by a few years. 17.
You were right.
Was it 93?
Yes.
That's what I said. Okay, I was right. Okay, 1793, right? So we're not even, my goodness, 4 years after the Constitution was ratified. And the people on this court were framers, right? They were involved in the Constitutional Convention. James Wilson was in Philadelphia, among others. Right? These are people who had, John Jay was one of the authors of the Federalist Papers, right? These are people who were very influential. And 4 years after the Constitution was ratified, even they didn't agree on what the meaning of sovereignty was. They couldn't even agree on that much. Right? Okay. So let's walk through the opinion. Let's see. So let's start with Iredell. So one note before we go too far into things. I think, Soros, you asked me this about a week or two ago. Did John Marshall write his own opinions? Oh, he wrote his own. Indeed, before Marshall, the practice in the court was that each justice would write their own opinion. It's what's called seriatim. Here, I'll write a few. So it's a funny word. Seriatim. I always spell it wrong. No, seriatim. Is that right? No, I never spell it right. There it is. Seriatim. Seriatim, which means basically in serial, one after the other. And what happens? Each judge would publish his own opinion. So there might be 5 opinions at the court. And then lawyers would have to figure out what the most narrow ruling is, figure out what the holding is. Here it's easy. It was a 4-1 vote. There wasn't much of a difficulty. But it was still a complicated question. All right. And so there were 5 opinions. Oh, let's do the facts first. Who's next? You next? Want to do the facts, please, Lindsay? In Chisholm, the facts are pretty simple.
So, after the Revolutionary War, the Executive Council of Georgia approved purchase of clothing from a South Carolina businessman. After the businessman died, the executor of his estate brought suit against Georgia in federal court, claiming original jurisdiction.
Good.
And yeah, I think those are facts.
Very good. Thank you. Okay. So the opinion, again, there were 5 separate opinions that we have to study, unfortunately. The first opinion by Justice Iredell is largely considered the majority opinion, even though it's not called that. I think his opinion is listed first because it was the first one delivered. But we're not exactly, I'm actually positive about that. I'm sorry? It was a dissent, but it was listed first. I think it was the first one published, which often confuses students. Right? It was the first one, but it was listed first. So let's see. I got a picture of Iredell somewhere here. Blair Olson.
We put it in the book as well.
Yeah, no, it's in the book. I want to see if I put it on the screen. There we go. Here he is. That's Justice James Iredell. Okay, so what's Chelsea? Walk me through Justice Iredell first.
Okay. So he believed that the king in England, the king had absolute sovereign, so he couldn't be sued. And when the king passed the power down,
Well, he passed. He sort of gave it up.
yeah. That the Constitution never actually abandoned the old law. So
Okay.
he still believed that
Very good.
the states couldn't be sued.
Yeah, very good. So again, the dissent came first, right? He was a lone dissent, and Iredell's opinion is fairly straightforward. He argued that after the Revolution, whatever sovereignty the king had descended to the states. And because there was nothing in the Constitution that clearly said that the states were giving up that sovereignty, we should presume they retain it. In other words, if the states were going to give up something really important, there'd be a clear statement rule. Think of like South Dakota v. Dole, right? When a state wants to give up something, it's got to be in writing, clear as day. For example, they gave up the power to declare war. Okay, easy. They gave up the power to regulate commerce between the states. Okay, right there. They gave up the power to collect taxes. Okay, right there. But the Article 3, Section 2 language is sort of, wishy-washy, right? We could read this in one way, in which case they were giving up their power. Or we could read it in a second way, in which case the plaintiffs are the states. Which way should we read it? Door number 2, right? Read the statute to avoid the states giving up an important power, which they now claim they retain. And again, we are 4 years after ratification. We are very early on. Okay, all right, so any questions with Justice Iredell? Okay, let's do Justice Blair. He's a funny face. I don't know what's going on with him. If there's some sort of defect or something, or maybe it was a bad painting. I don't know. But I mean, I don't know what's going on there. I have no idea. I think Audrey next. Yeah. Okay. So give me Justice Blair. It's.
He basically rejected the England following, like Justice Ireland did. But I guess the famous quote is that the Constitution is the only fountain from which I shall draw.
Yeah, I love that. It's a beautiful line, isn't it?
The
Yeah.
only authority
To which I shall appeal. Yeah, it's a beautiful line. And what what Blair is basically saying is, we did not fight a revolutionary war to maintain the king's powers. We did not wage this revolution, declare independence, to basically install a king by another name. Right? The even notion that someone could then be immune from suit, he thinks is a European concept and not a concept that belongs on this continent. Okay, with me? All right, Tyler, give me Justice Wilson.
So he was the one.
Randy loves Justice Wilson, by the way. It's one of his favorites.
That went a different way and focused on the we the people aspect.
Yeah,
So,
yeah.
You know, we talk about sovereign, but the general population doesn't even know what that word means. And Georgia, when ratifying the Constitution, agreed Article 3, Section 2 as it was written. Therefore, they're not, truly they don't have a right to be considered a sovereign state.
Yeah. Yeah, and he has this one line which I love, which is our Constitution opens with this magnificent object of we the people. The first personage is introduced. And for Justice Wilson, whatever power belongs not to the states, but to the people. And even if you think of the 10th Amendment, right, whatever rights reserved to the states, reserved to the states, respectively to the people. Right, the people are the basis of everything. And if you think of the Obamacare cases, where Randy loves this opinion so much, the notion of a mandate to force people to buy a commercial product, Randy argues, is inconsistent with the idea of sovereignty in the people. Right, the people have a sovereignty themselves. It's not only about the states, but about the people. They can't be forced to engage in a commercial activity. And this largely inspires how Randy approached the individual mandate case. Okay. So Georgia, whatever, it's a good state, but they're not sovereign. Right? The sovereign comes only from the individual, the majesty of the people. Everyone with me? All right, Suresh, you want to give me Justice Cushing, please?
Justice Cushing actually, he believes in what he says it's a controversy between the states. Different states. He believes that this is explicitly a constitutional issue.
Yeah.
And he wants to have it addressed as such.
Yeah.
And I feel like in my reading, and I could be wrong, I felt he was almost concurring with Justice Wilson. Or Justice Blair, actually, where he doesn't care about what the King of England or
it's like a textualist argument, right? I mean, he basically says, this doesn't make sense. If a state can sue a citizen, why can't they go the other way around, right? In other words, if a state is willing to drag itself to a federal court, then why can't they be dragged to a federal court? You can't have it both ways. If you want to use the federal courts to go after citizens, then sucks to you. You might have to get suits going the other way against you. Right? You have to be a defendant or you can be a plaintiff. It can go both ways. And Chief Justice Jay had some of a funny, I don't say funny, but like I always chuckle whenever I read this concurrence a little bit, because he has this point, right? You know, what if you have like a corporation, right, with like 40,000 people? Right? Can you sue the corporation? Sure you can. And what happens if like Delaware has like 40,000 people in the entire state or whatever it is, right? Like, what's the difference between a corporation of like, tens of thousands of employees and like the city of Philadelphia, right? Or, a corporation in the state of Delaware, it's like a little bitty state, like no one's there. And this, I think, echoes the fact that he thinks that a state and a corporation don't have any meaningful difference, that it's merely a collection of people, right? They have a government, perhaps, a Republican form of government, but it's not something that warrants an immunity from suit in federal court. And Jay also writes that, he writes, sovereign, let me show you a picture of Chief Justice Jay. I like this picture, it's a good picture. And sovereignty would do great violence to great and leading principle of free and equal nation. So he rejects the idea of sovereignty altogether. So you have 4 votes arguing that the states are not sovereign in Chisholm. And then you have 1 vote arguing that the state is sovereign. Okay, what happens next? Chisholm was decided in 1794. Judgment was rendered. Shortly thereafter, it was decided in 1793, and then about a year later, Congress proposed what would become the 11th Amendment. It's actually the text of it. It's sort of faded, but there it is. the text of the 11th Amendment. It was ratified less than a year later. This was the first new amendment that was ratified after the first 10 amendments were ratified in 1791. What we now call the Bill of Rights were approved in 1791. This was the first new amendment. And it was ratified very quickly. Within the span of basically a year, 12 states approved. This decision, Chisholm, was viewed as being very unpopular, although it's not exactly understood why it was unpopular. Right? Were the framers of the 11th Amendment unhappy by Article 3, Section 2, that now a state could be sued by a citizen of another state? Or were they unhappy about the debate about sovereignty? Right? Let's look at the text of the 11th Amendment. Okay, let me make this a little bit bigger so we can see everything at once. Oops. There we go. All right, very good. Okay, perfect. Okay, so you have here Article 3, Section 2, and you have here the 11th Amendment. It says, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. Okay. A few points. We have today two primary ways to get to the federal court. You know what they are, right? You have federal subject matter jurisdiction, right, 1331, and you have federal diversity jurisdiction, right, 1332. At the time the 11th Amendment was ratified, there was no federal subject matter jurisdiction. Federal question, I'm sorry, no federal question jurisdiction. It existed briefly and they got rid of it. Right? So for all practical purposes, the only way to get your butt into federal court was through diversity. Right? The only way to get into a federal court was through diversity. Okay, so let's just start from that premise, right? If the only way to get into federal court is diversity, then the framers may not have been worried about suing a state with a federal question because Congress did not give federal question jurisdiction. Everyone with me, right? If that's correct, and this, by the way, this is an issue which people disagree about vigorously, so I'm trying to be as neutral as I can. But if that perspective is correct, then the 11th Amendment cuts off all avenues by which a state could be sued. Again, if the only way to drag a state to federal court was through diversity, then this amendment cuts off the only way to get a state into federal court. One more time. If the only way to drag a state into federal court is diversity jurisdiction, then this amendment kills the only way to drag a state into federal court. But we know that the Article 3 of the Constitution also gives jurisdiction to questions arising under federal law. And in the 1880s, 1878, after the Civil War, I don't know the exact year offhand, in the 1880s, Congress actually gave the courts federal question jurisdiction. At that point, we have a new controversy. What exactly did the 11th Amendment do? Did it merely nullify Article 3, Section 2, such that the courts will not allow a citizen of one state to sue another state, right? the citizen of Texas can't sue Oklahoma. We all agree you can't do that. That's a no-no, right? In diversity jurisdiction. Right? You cannot sue another state. But did this amendment also embrace Justice Iredell's opinion? Did the 11th Amendment adopt Justice Iredell's conception of sovereign immunity? If it did, then you can't sue your own state either. Right? If Justice Iredell was right, and the framers of the 11th Amendment and those who ratified it understood Justice Iredell to be correct, then it wouldn't matter who you sue. Okay, now you may say, wait a minute, Josh. If they want to say that the states are sovereign, why didn't they just say that? Right? If they want to say that Justice Iredell is right, why didn't they just make an amendment that says the judicial power shall not extend to any suit by any citizen against any state? Right? Change the word of another to any. Change one word. Citizens of any state. Dunzo. Right? Why did they make this? You wouldn't be here today. It'd be a lot easier, right? If they just said citizens of any state, that's an easy question. We all know we can do this in 5 seconds. Why did they say another state? Here's the debate. One school of thought says the framers only understood that you can get to federal court by diversity, so this use of another was cutting off the one pathway to federal court. That's option A. Option B is because they were only killing diversity jurisdiction, but they were not addressing federal question jurisdiction. Right? Who's right? Oh my goodness, we can debate this for hours, and maybe we will. But those are the two sides of this debate, and the Supreme Court vigorously fought over this. And in fact, the court actually granted an 11th Amendment case about I think last week. So you might get something from the Roberts Court at this point. Maybe I'll muck it up a little bit more. Maybe something else to edit. Yeah.
Question. Wait, for some reason I thought, okay, wait. You may have to reiterate the two arguments.
Yeah.
Again, because for some
Yeah, happy to.
reason, I thought I read that citizens of another state. So I put, even though the text only says this, case law also adds that citizens cannot sue
Their own state. That's right.
Is that one of the arguments you said?
Yeah.
Oh, okay.
Yeah. Right. That's the sovereign immunity argument, right?
Oh, okay.
This says another. If they said any state, right, that would mean another state or your own state,
Your own state.
right? They didn't. They said another. So there are two ways of looking at this, right? One way is they use another because that was the only way of getting to federal court diversity. So this amendment would cut off every pathway to federal court. The other way is, well, they only want to kill the narrow context of Chisholm and nothing more. And so I say, but you can still sue your own state once Congress decides to give the federal courts a federal question jurisdiction. All right. Much of this issue turns on the fact that at the time of the framing of the 11th Amendment, there was not federal question jurisdiction. No arising under. 1331 did not exist. That only came around after the Civil War. So there was really no reason why you could go to federal court unless you had diversity of parties. You had another state involved. If you had your own state, you can never bring it to federal court. You'd be stuck with your own state's courts. Where the idea is you don't want to sue your own state because you have political process, right? This is my question to Lindsay and Chelsea 20 minutes ago, right? If your own state screws you over, deal with the political process. You can't use your own courts, don't go to federal court. Okay? Regardless of what the 11th Amendment meant as originally understood, for the first 100 odd years of the 11th Amendment, there were no state citizen suits. Why? There was no diversity. There's no federal question jurisdiction. So you have an entire century where lawyers came of age where they didn't know of such a thing as a citizen suing a state. It never happened because it couldn't. But then, after the Civil War, Congress approved of federal question jurisdiction. right? After the Civil War, Congress approved a federal question jurisdiction. And we get the first case, which is Hans against Louisiana. Right? A very, if you want to get a law professor to get angry, just say Hans v. Louisiana. And they'll, even those who agree with it get very angry when people disagree with it. It's a very contentious topic. All right. All right, who's next? Okay, I can never remember, this room's too small. All right, Lindsay, want to give me the facts on Hans, please?
Post-Reconstruction, Louisiana failed to pay interest on certain bonds they had issued.
Yeah, so these are fundraising mechanisms during Reconstruction, right? And they didn't pay their debts, right? So what happens when the government doesn't pay their debts? What's that called? Government owes you money. They don't pay. What's that called? Well, what's the cause of action?
They filed claiming a violation of the contract.
Yeah, but much more simply, right? Party says they owe you money, they don't pay. What do you call that? Breach. Yeah, simple, right? It's a breach. It's a breach of a contract. Now, instead of having a contract with a private party, the breach here was with the state of Louisiana. And by the way, I looked it up. It was $87,000. In present day value, that's more than $2 million. So this was a considerable sum of money, right? Now, Chelsea, could Mr. Hans have gone to the state court to sue the state?
Yes.
The state court.
No.
Which one is it?
Yes.
Do you think the state of Louisiana gave their courts jurisdiction to hear suits against the state? No, certainly not, right? It's not the case. That's fair, right? States do not give their own courts jurisdiction to sue the state because they don't want to bankrupt themselves, right? Why would the state open itself up to liability in its own courts? Like, screw you guys, right? And to this day, states don't open up their own courts. States have what are called claims acts, which allow you to sue a state in certain limited contexts, but you can't walk into a court in Texas and just sue Texas automatically. You have to go through specific hoops, right? Let's say, you know, a Texas state official commits a battery against you, right? You can't just walk into small claims court and sue them. You have to file paperwork, you have to request damages, and then maybe at the end of the process, if you can't reach an agreement, the state says, okay, now you can go to court. But that's a last option. Yeah?
So whenever, this is a civil procedure question, maybe I'm blanking out. So whenever we see titles that say Audrey versus Texas.
That's after you jump through all the hoops.
After you jump through all the hoops to get to federal.
Or a case where Congress allowed the state to be sued. We'll do that next case. We did Bernie.
Certain sections.
Okay? But here, Louisiana did not open up its courts to a lawsuit by a citizen of its own state. Right? So the grievance is involving Hans and the state of Louisiana. Hans can't go to Louisiana court. I'm sure he tried to ask his representatives in government, and the people in Baton Rouge said adios, or actually au revoir, I suppose. So instead, Hans went to federal court, right? And he claimed a federal question. And Chelsea, what was the federal question he claimed?
The breach of contract.
Contracts clause, right?
Yeah.
Right, in Article 1, Section 10, right? The Contracts clause says that states cannot violate contracts. It's in there, right? Article 1, Section 10. And he asserted jurisdiction under what's now 1331, the arising under jurisdiction. Right, so the question becomes, as a general matter, does the federal court have jurisdiction over a federal question like a breach of constitutional clause? Yeah, they do. Is this a question arising from federal law? I think it is. Does the court then have jurisdiction? And that's the question, Hans. All right, Audrey, walk me through, please, the court's analysis in Hans.
I guess they basically first started off listing Hans's argument, and then they went through and said, I mean, the overall holding, they basically just said that, no, that the 11th, they went to the 11th Amendment and said that that prohibits the state from being sued by its own citizens.
Okay, Audrey, so how did the court deal with the actual text of the amendment versus what it says versus what the court holds that it says?
I'm trying to remember.
It's a very, very funny opinion the way they wrote it.
I'm trying to remember.
You gotta deal with the language somehow.
I guess they went through. Wait, say it one more time.
How does the court deal with the fact that the text only concerns suing another state, not your own state? How do they deal with that?
I don't know why I can't remember.
That's an important thing. Tyler? Tyler?
Bradley was like, yeah, that's what it says, but, I mean, if you read it that way and meant it that way, it would be, I think, anomalous.
Bingo.
results.
Yeah, there's the magic word, anomalous.
So you can't read it like it's actually written, you've got to read it to implicate that it also means of their own states.
Yeah, very good. Very good. Thank you. Justice Bradley writes, it is true that the amendment does so read. In other words, you can sue another state. You can't sue another state, which means you could sue your own state. But this creates an anomalous result. What does anomalous mean? It'd be odd that a state can be sued by its own citizens, but not a foreign citizen. In other words, it's opposite what we would think. I asked this question at the beginning, right? If Texas wrongs you, you can complain to your local representative. If Oklahoma wrongs you, you can't. So it would make more sense to be able to sue a foreign state. But here, the government that's responsive to you can be sued, and the government that's not responsive for you cannot be sued. It's backwards, right? Why should you sue your own government when you can't sue a foreign government? The majority then effectively says that's too weird. We don't want to reach that result. Now, there's a problem, right? The text doesn't get there. What then does the court actually say the 11th Amendment does, Sarosh? If it's not doing what the text says, what does the 11th Amendment accomplish?
I'm reading this too. It was, I'm taking a gander at it because I don't remember on the top of my head exactly what it said.
Well, let me look at it this way, right? What were the two ways of reading Chisholm? Right? What were the two approaches in Chisholm?
Either you're completely cutting off all the diversity, either cutting off diversity, that was the only way to get to the federal court, or you are limiting it to just foreign state.
Well, you're correct. You're reciting what it said a few minutes ago correctly. But more generally, how did Justice Iredell understand?
But that it was the sovereign immunity was retained by the
Yes,
states.
exactly. Justice Bradley effectively says the states were sovereign when the Constitution was ratified. The states were sovereign when the 11th Amendment was ratified. In other words, Bradley says Chisholm was incorrect when it was decided. Therefore, the states were always sovereign. Everyone with me? But Sarosh, if the states were always sovereign, then what did the 11th Amendment actually do?
Basically reaffirming their sovereignty.
Did it actually change anything?
No.
Bingo. According to the majority in Hans, the 11th Amendment was basically superfluous. It wasn't necessary. The states were already sovereign before. The court screwed up in Chisholm. Nothing changed. So therefore, it doesn't matter what the 11th Amendment says. It doesn't matter if it says any state, all states, any state, your state, it's irrelevant. Right? Because Iredell was correct, and because the states were sovereign at the get-go, the 11th Amendment was not necessary. In other words, Hans would have been decided the same way, even if the 11th Amendment was not ratified. Justice Iredell was right. The states can only be sued if they consent to the lawsuit. Yeah, Audrey.
So with the question of did the 11th Amendment reverse the Chisholm majority's holding that the states lacked sovereign immunity?
Well, according to Justice Bradley, Chisholm was wrong. Chisholm was wrong when it was decided, and therefore the 11th Amendment was really unnecessary. So the text is not so important. It's as Justice Souter discusses later, it's like we have two 11th Amendments, right? The one ratified in 1790, was it 5? And another one which was ratified in Hans, Louisiana, 100 years later in 1890. This is a huge point of contention where the court basically says this amendment to the Constitution, the text doesn't really matter. What matters is concept of sovereign immunity, and that's what prevails. Yes, sir.
With all due respect to Justice Bradley, how does he know what? How could he say that 4 of the 5 amendments were part of framing the U.S. Constitution got their understanding of the Constitution wrong?
Well, I mean, I'll defend Bradley for a bit. Think of Madison and McCulloch and Hamilton, right? In the very first years after the Constitution was ratified, you have James Madison, Jefferson on one hand, and you have Hamilton the other ones, and they disagree with that really important question, right, about the scope of Congress's powers. Even at the time of the framing, we didn't agree on stuff. So it's not insane, right? Bradley's holding, I don't like it, but it's not insane, because if within 1 year of this decision, the people were so angry they amended the Constitution to ratify it, that might be a symbol that Wilson and Jay and Blair and Cushing maybe screwed up. So it's not, I think Wilson was correct as an original matter, but it's not completely irrational to hold that the people responded. And frankly, I like the idea that if the Supreme Court makes a decision and the people aren't happy with it, you change it.
I mean, I'm okay with that too, but my contention, I guess, comes with like when he's saying that the 11th Amendment.
Well, you know what? We think Iredell was right and the states are sovereign. And that's in the record of which it was ratified. Would that change your opinion at all? So even if the people said, who voted to ratify the amendment, we agree with Iredell, he was right.
I mean, yeah, then it would, because I mean, to me, that's them amending what they thought was.
Okay, but now.
An unnecessary ambiguity in part of the framers.
Yeah, but now you know my follow-up question. There is no such history, one way or the other. We don't know. We actually don't really know why they ratified this amendment. It's one of these mysteries. We know they did it quick.
Mm-hmm.
We know they weren't happy with Chisholm, but we don't know exactly why they did it. So Justice Bradley drew an inference. He says the opinion that they supported was that of Justice Iredell, and it's not an insane inference. And if that's right, then the 11th Amendment merely cut off the only path that was available to sue the states as a reflection of sovereign immunity, right? The 11th Amendment reflects, it's not the words, but it's the background principle, you might call it. Again, there's one of the things I go back and forth on. I'm positive, I think Chisholm was correct when it was decided. I think Hans was probably wrong, but I can be persuaded. I go back and forth. It's these things I think about a lot. I think Harlan, as usual, has the best opinion, right? Justice Harlan basically says, I'm with the court, I concur, but Chisholm was right when it was decided. So basically, Justice Harlan is saying that Justice Wilson and Chief Justice Jay and these other framers were correct, and that the people then disagreed, and which is fine, right? The people can disagree with 4 of the 5 justices. They're allowed to do that, and they can amend this Constitution, and they change it. But then what they change it to, and Harlan here went along with the majority.
I feel most comfortable with Justice Harlan's concurrence than I do with the majority.
Yeah, I'm probably there. And also keep in mind, by this point, there have been 100 years with no citizen suits, right? It was a fairly well-established practice that you couldn't sue your own state. You couldn't sue another state. And had this court come out differently, it would have opened the floodgates to allow citizen suits. And you can imagine the court didn't want to open up the federal courts to all these suits against the states. Because then the states would have to start getting judgments against them, which the federal courts would enforce and say, oh, you have to open up the treasury to pay so-and-so judgment, $2 million, whatever the amount was. So again, I used to think Hans was completely undefensible. Now I think maybe it's defensible, probably wrong. I go back and forth. These are hard questions. As long as you get both sides, I really don't care which way you come down. It doesn't matter to me. I don't agree with myself most of the time. I don't. Okay. Questions on Hans?
In the
oh yes, please go ahead.
I'm sorry. In the text, you mentioned a component of a Justice Marshall opinion from I think Fletcher v. Peck prior to going into the Hans case. What from that section do you consider overlooked?
I would not worry about this. It's a case I didn't assign, and it's very important to Randy, not so important to me.
What do you mean? Which case?
Fletcher v. Peck. It's in the book. I don't assign it.
This is. I mean, it's just it's an excerpt on page 383.
Yeah, I wouldn't worry about it.
Okay.
Yeah, don't worry about it. Okay. All right. Any questions on Hans? All right. Let's go into the next case. Okay. So after Hans, the rule is you can't sue another state. You can't sue your own state unless the state consents. That's the general rule. However, Congress has a power that's very important. It's a very important power. Congress has the power to waive. That's not like bye-bye, like you wave, right? Like hand emoji. No, it's not a waive. It's W-A-I-V-E. Waive. Sounds exactly the same, but it's W-A-I-V-E, waive. Or abrogate. A-B-R-O-G-A-T-E, abrogate. Congress can waive or abrogate a state's sovereign immunity. In other words, Congress can open up a state to be sued. Generally, states can't be sued, but Congress can say in federal court, we will allow you to be sued. And indeed, Congress can allow a state to be sued in state court also. Much more controversial. All right. How? The primary mechanism that allows a state to be sued is Section 5 of the 14th Amendment. That's not the only way. There are other provisions. But the primary way that the states can be sued, that Congress can allow the states to be sued is Section 5 of the 14th Amendment. We will study Section 5 again later this semester. We'll come back to the 14th Amendment at some length. We actually touched on it very briefly when we did Heart of Atlanta and Katzenbach. You might recall that the court upheld the Civil Rights Act of '64 based on the commerce and necessary and proper power, right? That the regulation of local segregated businesses was economic activity, which in the aggregate had a substantial effect on interstate commerce. You may recall that Justice Douglas had a different perspective. Justice Douglas said that Congress has the power under Section 5 to enact appropriate legislation to enforce the equal protection of the laws. Only Justice Douglas accepted that position. The court has never given much weight to the Section 5 power with respect to, for example, prohibiting segregation. But they've given a lot of consideration to Section 5 in the context of waiving or abrogating sovereign immunity. Section 5 says the Congress shall have power to enforce by appropriate legislation the provisions of this article. What are the provisions of this article? It refers back to sections 1 through 4 of the 14th Amendment. And Section 1 contains the Equal Protection Clause, right? nor shall any state deny to any person within its jurisdiction the equal protection of the laws. So the argument's this. If a state is denying a person the equal protection of the laws, Congress can then enact legislation that allows a state to be sued for denying the equal protection of the laws. I'll say that again. If a state is denying the equal protection of the laws, then Congress can pass a law to open up the federal courts so that the state can be sued, right? Private lawsuits were an important mechanism to keep the states honest. If the states were depriving people of their rights, then Congress can then intervene and allow citizen suits. Make sense? There's another provision of the 14th Amendment, Section 1, that's relevant. It says that a person cannot be deprived of life, liberty, or property without the due process of law. Again, a person cannot be deprived of life, liberty, or property without due process of law. Therefore, if a state is depriving a person of liberty, Congress can use its Section 5 powers to waive the state's sovereign immunity and allow the person whose liberty was violated to sue the state, right? The Congress can open up the federal courthouse if a person's liberty is being violated. This makes a lot of sense. This way, Congress doesn't have to step in every time there's a violation of rights. Individual citizens can go to federal court to vindicate their rights. Have you all heard of Section 1983? Right? Where you sue for civil rights violation? Right? Why can you sue a police officer for police brutality, for example? Because Congress waived the state's sovereign immunity for violating your rights. That when the state violates your rights, you can go to federal court and sue a state official. You do not need the state's consent if the state is violating your constitutional rights. Why? Because the states don't have the power to violate the Constitution. By violating the Constitution, the states have gone beyond their powers. Congress can then make those actions subject to liability in federal court. This is what's called Section 1983.
So Sebelius, as the Secretary of...
She was a federal
State,
official, though. Federal.
But is that the same principle, that she was, as head of that agency, was going to enforce unconstitutional provisions?
Yes, you can always sue a federal official to stop her from engaging in unconstitutional actions, right? It's a much more difficult question if you can sue for damages, right? You generally can't sue the federal government for damages unless Congress creates a cause of action. There are some exceptions. Make sense? Okay, again, so here's the idea. If Congress deprives you of liberty protected by the 14th Amendment, if a state deprives you of liberty protected by the 14th Amendment, the state acts unlawfully. And Congress can then enact legislation, a law, a statute, that allows you to go to court and sue them for damages.
But there has to be a law or statute.
Yes, and that's legislation.
Federal Tort Claims Act probably includes damages.
Well, the Federal Tort Claims Act is a waiver of sovereign immunity for federal employees, right? Not states. So it's a little bit different, right? Congress can limit its own powers however it wants. But here we're talking about suing state officials, not just the federal officials. Make sense? Okay, stick with me. All right, I need to take a slight detour to talk about free exercise law. You will now be required to take a class in the First Amendment. It's a very important class. You might even have me for it. Not this year. Oh, did you get the schedules yet?
Oh, yeah?
Oh, I have mine. Oh, I can't show you. I'm not teaching anything else useful for you next year. I'm doing property and common law.
Property one?
Not in the fall. No, I'm teaching property 2 in the fall. I'm sorry. I'm teaching property 1 in the spring though. Sorry. I'm teaching property 2 in the spring also.
Oh, what section? Okay.
I think I'm actually teaching the night section in the spring.
Do you have your section in the fall?
I'm teaching property 2 in the spring from 7:45 till 9:15 p.m. Yeah, it's not the best. My schedule in the spring's not that hot.
Do you have your section in the fall?
In the fall, I don't know what section letter I am, but I'm doing ConLaw and Property 2 in the fall. Sorry.
No, I mean, I may have you.
Property 2?
Mm-hmm.
I'll look later, I'm not sure. The reason why I can't show you is these things change around and I'll get in trouble. But I only got mine last Friday. I think like yours is coming very soon.
Oh yeah, no, ours definitely, because I was looking last Friday. I know ours
It's
is
not
in
that
there.
big.
No, it's not there yet, but because we haven't approved it yet. Like it was. Hold on, I'll tell you when you're gonna get yours. That much I can tell you. Your registration begins on June 25th. I think you should get yours probably by next week, I think. Okay, sorry. Yeah, no, I only got mine I got mine, I think, on the 4th. When was the 4th? Was it Friday night? I got mine like 4 or 5 days ago. Very, very, very short time. Okay. Anyway, so need to take a brief detour on the First Amendment. So the First Amendment provides that Congress shall make no law abridging the free exercise of religion. The First Amendment only speaks of Congress. But the court has held that one of the liberties protected by the 14th Amendment's Due Process Clause is the right of free exercise. This is what's known as incorporation, where the Supreme Court has said the word liberty in the 14th Amendment protects the right of free exercise, and states cannot then deprive you of that liberty. Therefore, states cannot deprive you of free exercise rights. We will do incorporation much more later this semester, but that's the general gist. Okay. So Congress cannot deprive you of free exercise rights, and the states cannot deprive you of free exercise rights. What happens if Congress finds that states are depriving you of free exercise rights? Under Section 5, the states can then enact appropriate legislation to allow you to sue the states for violating your free exercise rights. Right? Congress can intervene. The next case, Bernie v. Flores, City of Bernie versus Flores, raises an important question. Who gets to decide what liberty is? Or more precisely, which branch of government gets to decide what violates the free exercise of religion? Does Congress get to decide? Does the president get to decide? Or do the courts have a monopoly on interpreting the Constitution? Guess which one the courts picked? Monopoly. If you learn nothing from me at all, it's that the courts do not have a monopoly interpreting the Constitution. Bernie makes me very angry at this decision. I don't like it for a lot of... I think it's probably right, but parts of it make me angry. I go back and forth. I always get angry. Let's talk about Bernie for a minute, right? In the 1960s, the Supreme Court decided a number of cases involving free exercise. And the court basically said that if laws impose a burden on religion, a substantial burden on religion, then the government has to show a really important reason why they're doing it, right? The Supreme Court more or less reversed that in the 1990s in a case called Employment Division versus Smith. Smith held that if a law is neutral, that is, doesn't target one specific faith, then the government can really do it for any reason. They don't need a very good reason, right? If the government wants to ban peyote, which is like a hallucinogenic cactus, they can ban it. They don't need a good reason why. They can ban it, even if that affects people who use it for Native American ceremonies. Right? I'm not going to get into Smith now. It's an unpopular case. Shortly after Smith was decided, Congress enacts a law called a RFRA, RFRA, the Religious Freedom Restoration Act. The Religious Freedom Restoration Act, RFRA. RFRA did a lot of things, but at its most basic level, it tried to restore, bring back the First Amendment test before Smith. What's called the Sherbert test, not like the ice cream, but it's called Sherbert versus Werner. Right? Smith basically killed Sherbert, and RFRA said we're going to bring it back. That if a state imposes a substantial burden on religion, that's a no-no. What happens if a state does that? Then the person whose religion is burdening can go to federal court and sue the state for burdening their religion, and they get damages. Right, so RFRA was an exercise of Section 5 powers. Congress said we're enacting legislation to ensure that people are not being deprived of their liberty. Everyone with me? Right, everyone understand the general gist? Okay, who's next? I've lost count. I think you're next, yeah. You want to give me the facts, please, and Bernie?
Archbishop Flores, the Catholic Archbishop of San Antonio, had applied for a building permit to the city of Bernie to enlarge the church.
Good.
And the local zoning authorities denied.
Why did they want to enlarge the church? Is actually an important reason.
It had to do with the landmark, or the church had been growing.
Yeah.
And they needed more space.
Yeah, this is actually an important reason. The bishop argued that his free exercising religion was essential. They needed more room, right? In order for this parish, this church, to have enough space, physical space, to fit all their congregants in, that he needed more room. He needed a bigger church. You haven't taken Property 2 yet. I think you will at some point, maybe with me or not. But in Property 2, you guys will learn that zoning disputes are very deferential to the government. When the government declares that property is a landmark, you lose almost all value in your land. You can't make changes to the structure, the external structure, without going through a lot of approval process, which you're not going to get. And generally, when the government says you cannot build, that's the end of the road, too bad. Now, the city of San Antonio didn't do this because it hates Catholics, right? They didn't do this to target Archbishop Flores. They enforce the law because it's a neutral landmark law, right? The same way you can't, tear down the Alamo or some other famous historical structure, you can't tear down this church. Now, had RFRA not been enacted, Archbishop Flores would have been screwed. Under Smith, which was the law at the time, there's nothing you can do, right? He's out of luck. The law burdens him, but it's a neutral law, so it doesn't matter. Now, because of RFRA, though, Archbishop Flores has a leg to stand on. He can go to federal court and say, aha, because of RFRA, they burden the state. By the way, the city of Bernie is basically an aspect of the state, right? When you sue the city, it's the same thing as suing the state. Cities exist by virtue of the state, so they're just arms of the state. So bishop went to court, and the bishop says, this is burdening my religion substantially, and I want to get damages. I want my permit, and I want damages. I want attorney's fees as well. The court never actually decides if the denial of the permit imposes a substantial burden on his religion. I don't know if it did. Maybe it did. Maybe it didn't. I have no idea. Instead, the court had to decide, was RFRA even constitutional? Specifically, could Congress open up the states to a lawsuit in federal court for burdening religion? And I'll make it even more complicated. Could they open up the states for burdening religion in a way that the Supreme Court said could not, right? It wasn't the case that San Antonio was violating the Constitution as the court interpreted. If Bernie was violating the Constitution as the court interpreted it, that's easy, right? If any state runs afoul of the Supreme Court decision, then they can be sued. There's no doubt about this. But instead, RFRA tried to do something else. It was adding on top. It was saying, states, even if you're not violating the Constitution, if you violate the Constitution as we interpret it, that then gives you civil liability, right? They were expanding the scope of religious freedom protected by the Free Exercise Clause as interpreted by the Constitution. So there are two elements here, right? One, could Congress redefine what free exercise meant? And two, could Congress then waive a state's immunity based on that new interpretation of the First Amendment? Right? Think of it again twice. First, could Congress reinterpret the First Amendment? And second, could Congress waive a state's sovereign immunity based on that reinterpretation of free exercise? Everyone with me? I'll give you the answer to the first question because it's easy. No. Congress cannot redefine the Constitution, right? The court says in very broad terms, it's our job, not yours. You guys get to define statutes, you can interpret law, but the free exercise clause, that's our baby. By no means is that necessarily correct, and this is the part that usually makes me angry. The second part I can go along with, maybe, I don't know. But the first part about the court saying to the Congress, you have no role in interpreting the Constitution, that one always sits a little funny with me. It truly does. It's a notion what's often called judicial supremacy, that the courts are supreme. And that's a fairly modern concept. It came around in the 1950s, perhaps. It doesn't come from John Marshall. It doesn't come from Marbury. It's a fairly modern concept that the courts have supreme. John Marshall wrote that all branches of government, all departments have an oath to the Constitution. All branches of government interpret it. So that's the first part. I don't want to dwell with you on the first part because I think it's beyond the scope of our reading. The second part, though, can Congress allow the state to be sued when the state is not violating the Constitution? That's the harder question, right? Can Congress allow the state to be sued even when the states are not violating the Constitution? All right, Audrey, so what do we got here?
That, I guess, from what I got from his holding was that in between, that there has to be, Congress has to there has to be a line drawn between remedial and substantive.
Okay, well, let's take this one step at a time, right? What's the difference, Audrey, between remedial and substantive legislation? Let's start there. A simple point.
He defines remedial as...
This is Kennedy, right?
Yes, as enforcing the provisions of the 14th Amendment. So Congress, Section 5 allows Congress the power to enforce the provisions of the 14th Amendment.
What do you mean remedial? Just what does remedial mean?
Oh, it's...
What's the verb of remedial? The verb is easier than the noun.
like a remedy.
Remedy, good, yeah, remedy, right?
Yeah.
In other words, the states did something bad, and you can then remedy that, right? So if the states engage in some sort of misbehavior, they violate the law, the Constitution, then the states can intervene, or Congress can intervene. That's remedial. Okay, now what's substantive, Audrey?
And then substantive, I'm trying to forget, but I think it's this substance of just the entirety of the 14th Amendment, I would think,
Tyler, take a step.
So substantive, you're not fixing, you're changing, essentially.
And then what were they changing here?
They were changing what the court had already ruled on as legal in Davis.
Smith,
yeah.
Very good. The substantive means they were changing the substance of the 14th Amendment, right? The content. When I say substantive, I mean the content, right? Substance, the content, right? Think of like a bucket. What are you pouring into the 14th Amendment, right? What are you pouring into it? If you're pouring in some new wine, for example, right, you're changing the substance of it, that goes too far. Congress cannot make substantive changes to the law by virtue of the Section 5 powers. They can only remedy violations of the law that were identified by the court. Again, this is the concept of judicial supremacy. Everyone with me? Okay. So now we know, Soros, Congress can enact remedial legislation. Okay, so then is RFRA constitutional?
No.
Why not? What's the test that the court gives to articulate why RFRA is not constitutional?
I want to say it was a Katzman v. Morgan case. It comes from that.
It comes from it. What's the test they actually give?
Oh, would it be the thing that they posted out up in the front?
I'm sorry?
At the very beginning. Oh no, it's Congress compelling interest.
No. Okay, you're on the right track. Involves the means and the ends. What's?
Congruence and proportionality.
Okay, very good.
Is it called
The fit. Okay, I think you're on the right track. Okay.
I don't know what it's called.
All right. The court here employs a test that drives students nuts, and no matter how many times I teach it, I don't think I ever do it well enough. But it's called the Congruence and Proportionality test, which is just an awful. Like, if the justice knew how hard this crap was to teach, I think they'd be a little more precise, but they don't care. They don't care what I say. The Congruence and Proportionality test, right? Why is that name so awful? Because congruent is a synonym for proportionality. They mean the same thing. Congruence is a synonym for proportionality, right? What do they mean? They balance out, right? Like, if you have shapes that are proportional, they're roughly the same size. If you have shapes that are congruent, they're roughly the same size. They mean the same damn thing, right? They mean the same thing. Congruence and proportionality mean the same damn thing. Why do you have to say it twice? I don't know. Why don't you say congruence test? I don't know, it sounds better. I don't know. But there has to be a balance or a fit, F-I-T, a fit between what Congress is doing, the means, and what Congress is trying to achieve, which is the ends. Okay? There has to be a fit between the means and the ends. All right, so what does that look like? Okay? I like this graphic. This graphic's actually helpful. And if you watch this video in particular, I think the video is particularly helpful to understand this, but I'll do my best. Right? So we ask, what is, okay, let me read this. So I said, there must be a congruence and proportionality between the injury to be prevented or remedied and the means adopted to that end. Okay? What is the injury to be prevented, right? What are they actually trying to stop?
Violation of the First Amendment.
Very good, thank you. In this case, it's the violation of the Free Exercise Clause. And how are they getting there? Very good, right? Right? And specifically, it's not just RFRA, it's money damages, right? The violation of the law is that your free exercise rights are being violated, and the end, like the goal that you're actually going there, is you're allowing the states to be sued in federal court for violating free exercise. Right? So when the government burns your religion, can you allow then the state to be sued for money damage if they don't meet this test? And the short answer is no. The court finds that the remedy is so far out of whack to the injury. What do I mean by that? Okay, we all agree burning religion is bad, right? No one wants to burn religion. No one wants to burn religion. But to open up a state to financial liability whenever they have such a burden, whoa, right? Slow down there, right? Maybe you could do something a little bit more precise, right? Instead of opening up the state to all manner of liability, maybe you can just have, if there's some really egregious violations of the law, right? Something very terrible, right? In other words, the government can't open up the state for liability for any reason at all. They have to have a very specific reason why. Think of this case. This was a mundane zoning dispute, a boring zoning dispute between the Archbishop and the city. Do you really want to drag into federal court every single zoning dispute that might involve a church? No. There's such a big gap between the sort of boring zoning disputes that issue happen every day and dragging a state into federal court, right? The federal courts will be overwhelmed. I think this comes out in the opinion, right? The federal courts will be overwhelmed if every little stupid zoning dispute results in a federal lawsuit. So here, in Bernie, the fit between the means and the ends is far too great, right? It's such a big gap. Now, you may ask, Josh, well, what's a good example, right? Well, he signed two other cases, which I want to walk through now. You have Morrison, which we actually studied already, and you have the last case, Nevada versus Hibbs. The last case, I'm going to cut to the chase a little bit, the court found there was an adequate fit, that the fit was okay. The second case, it wasn't. So let's talk about Morrison for a little bit. We do the facts already. I'll recite them briefly. But in Morrison, right, in United States against Morrison, the court held that the Violence Against Women Act was unconstitutional in part because Congress couldn't create a federal cause of action under the Commerce Necessary and Proper Clause. Why? Gender-motivated violence was not economic activity. We did that already. But there's another aspect, right? Christy Brazoncala, or actually I think she's pronounced it Broncala, I think the Z is silent. Christy Broncala sued the University of Virginia, Virginia Tech, which was a state college. As a result, the question was, could Congress waive the state's sovereign immunity under Section 5? So again, Congress said when there's any gender-motivated violence, then the person can sue the state. So Lindsay, what did the court say in terms of Section 5 here, waiving sovereign immunity?
They said that Congress lacked the power under the 14th Amendment to create a civil cause of action for gender-motivated violence.
That's right.
And the civil remedy was not corrective in character.
Very good.
And did not counteract or redress the operation of such prohibited state laws or proceedings of state officers. Instead, it redressed private discrimination and was outside Congress's power to enact.
Very good. Did Virginia Tech's conduct violate the Constitution? Right? If you remember, they basically took no action when a female student was raped by football players. Remember this one, right? Did that violate the U.S. Constitution? The court says it didn't, right? Because it was not remedial, it was substantive. It was actually trying to change the meaning of the Equal Protection Clause, right? So then we go to this congruence and proportionality test, right? If it was simply enforcing what's in the Constitution, it's okay, right? If it's remedying constitutional violations, it's easy, right? States can't violate the Constitution, therefore they have no power to be immune in those cases. But because they were not violating the Constitution, we have to consider the congruence and proportionality test, right? We have to consider this test, and we have to ask ourselves, what was the injury here? What was the wrong? BC University covering up a rape investigation. What was the means they were using to remedy that problem? Dragging the state into court to be sued for damages when they have these sorts of gender-motivated violence cases. Was there a fit, a close fit, between gender-motivated violence and opening up a state for civil damages? The court says no, right? The range of conduct, gender-motivated violence is a broad category. And there's so many different ways that that conduct can be engaged in that the court's not comfortable with allowing civil damages in that case. In other words, if Congress wants civil damages, they have to be more precise. Everyone with me? And that brings us to the last case. Nevada Department of Motor Vehicles or Human Resources. I always forget. There's another case involving motor vehicles. It's the Condon case. Chelsea, so what was the law at issue in Hibbs?
The FMLA.
FMLA, Family Medical Leave Act. And what does that law provide?
It gives men and women at least 12 weeks of.
Is that paid?
Yes.
No, it's not.
Oh, it's not.
You guys haven't worked yet. No, it is unpaid, my friend. In other words, a state's obligated to give you unpaid leave. Now, they can't fire you for taking those weeks off, but they don't have to pay you for it either. In other words, after those 12 weeks, whatever it is, your job's waiting for you when you get back, but there's no guarantee you get paid during that leave. Okay? What happens if a state failed to give a person that leave? What could the employee then do to the state employer? Right? So you're a state employee, you work for the Nevada Department of Human Resources, whatever, right? And the state doesn't give you your leave. What do you do then? Okay, so the question is, could Congress waive Nevada's sovereign immunity by virtue of the FMLA?
Yes.
Okay. Now, first off, is the denial of unpaid leave a violation of the U.S. Constitution? No, it's not, right? It's not remedying a violation of the Constitution. So it's substantive, right, in nature. Does the court find that there's an adequate fit between denying someone paid leave and allowing the state to be sued?
Yes.
Okay, why is a fit okay here?
Because it prevents the gender discrimination of just women having time off from work or it not becoming as important for them.
Okay, very good, thank you. The court, and the majority was actually by Justice Rehnquist, who wrote the other cases. He finds that here there's a very close fit between the means and the ends. Let's walk through this, right? In RFRA, any government action that imposed a substantial burden on free exercise could give rise to a lawsuit. That's a wide range of human activity. In Morrison, any gender-motivated violence, which is a very wide range of human activity, any gender violence could give rise to civil damages, too much. But here, this is not any form of sex discrimination. It's a very precise form of sex discrimination. Specifically, the refusal to give a person this leave, unpaid leave. And if the state does this one bad thing, then they're then open up for damages. And the court finds that there's a fault line between work and family, where sex-based generalizations remain the strongest, and it affects only one aspect of the employer relationship. Okay? And this is a way to perhaps prevent and deter other unconstitutional conduct, which could be gender discrimination. Yeah?
So, I guess in the context of Madison, it just needed to be more narrow. So I'm trying to think, like, since it's violence, I mean, violence can be broad, but it seems like...
I mean, had Congress passed a statute that, let's just say, sexual assault, right, or even rape, if Congress passed a statute saying it shall be, if a state fails to investigate rape claims, they may be liable for damages, that may be closer to the Hibbs case. I don't know, but that's a little bit closer. But the statute's pretty broad. It's all gender-motivated violence, which can be verbal abuse, emotional abuse. It's a pretty wide range of human activity. It's not satisfying. I get you. And I put a little note at the end of the case about Hibbs. Justice Ginsburg gave a speech some years ago where she suggested that Justice Rehnquist kind of caved in Hibbs. At the time, he had a single, well, his daughter was a single mom and was sort of working her way through the world, and he had perhaps some sympathy for her. I don't know if there's any truth to that, but without question, the law in Hibbs was more narrowly tailored than was the law in Morrison and was the law in Birney. Birney was very broad. VAWA, the violence against women, was a little bit more narrow, and then the FMLA, the Leave Act, was even more narrow. So maybe wherever the line is, FMLA was on the right side of the line. Okay, so everyone with me? All right, so any questions on the trilogy? There are other cases which I didn't assign. You can read them if you want. But the RFRA, Morrison, Hibbs trilogy of cases, there were like 5 of them. In the 90s, this was like a huge thing of when can Congress abrogate a state's sovereign immunity. There were all these cases, and it sort of just went nowhere. Right after Hibbs, the entire thing just died out. This is like this huge thing people were worried about, and didn't really go anywhere. There's actually a case next year. The facts are kind of cool. Where the state of North Carolina, off the waters of North Carolina, a Blackbeard, the pirate, one of his ships sank, centuries ago. And this guy, an explorer, found Blackbeard's pirate ship. Cool, right? And he actually took some underwater video of it. And then the state of North Carolina was using the footage without his permission, didn't pay him for the copyright. And so basically the individual sued the state of North Carolina for violating his copyright. Congress had enacted a statute saying that the states could be sued for violating copyright. And now North Carolina asserts the statute's unconstitutional because they can't waive their sovereign immunity. So this is actually not even a Section 5 case. It's the, there's a clause in the Constitution about promoting the progress of science and useful arts, whether Congress can validly abrogate a state's sovereign immunity under the useful arts clause. Yeah. And the court grants its review for that case next year. It's a fun fact about it with the Blackbeard pirate ship. But it's actually about sovereign immunity. What's that?
That'll be fun to read.
I'm looking. I think they granted it because it was fun facts, and they they're probably bored with all this other dramatic crap. Okay, so that's the IP case. Why am I assigning these cases in this topic, right? If you think about it, we were talking about Congress's enumerated powers. Section 5 is a very important enumerated power because it gives Congress the power to restrict the states. Right, the same way that Congress can regulate banks and regulate the sale of local wheat in a state, they can also restrict whether a state itself is sovereign. So this is an important power under Section 5 that Congress has. Okay. Any questions on Section 5 or Federalism or the 11th Amendment or Hans? David, give us a preview. What's on tap for tomorrow?
To what extent he can issue executive orders and pretty much strong-arm states into doing what he wants. And basically we're speaking about it in the context of the Korean War, and I don't know if you want to go further.
Yeah, go as much as you want. You've been quiet today. I like it.
Okay.
Yeah.
All right. Well, do you want me to just give you facts?
No, just what's the gist of the case? Which branch of government are we talking about tomorrow?
We're going to talk about the legislative and executive.
Very good. Very good. Okay, thank you. That's what I was looking for. Okay, so for tomorrow, we move on from Congress to the executive branch. And we decide what is the proper allocation of power. How are the powers balanced, or how are they proportional, you might say, between the executive branch and Congress, and then invariably when the executive branch and Congress go to the courts, to what extent can the courts step in and intervene? And we'll be doing, was it 3 cases for tomorrow? So we're doing ex parte merriment, which is a case decided during the Civil War, of whether President Lincoln had the power to suspend the writ of habeas corpus. And then we'll be discussing the Emancipation Proclamation, of where Lincoln actually had authority to emancipate slaves. And then we'll be doing Youngstown Chain Tube Company versus Sawyer, of whether the president has the power to seize steel mills during the time of war. All right. Any questions? All right, I will see you all tomorrow.